Welcome to the best hour of their day podcast with your hosts, Jason Fernandez
and me, Jason Ackerman. With more than 20 years in the business,
as both coaches and affiliate owners,
our passion is to help create world-class affiliates
and coaches by building
better boxes. Welcome to
the best hour of your day. All right, guys, we are back to talk about legal stuff. Matt from Gym Lawyers, he's the traveling gym lawyer. We're going to change his Instagram handle to the traveling gym lawyer.
The traveling gym lawyer.
You're a gypsy at this point, just traveling around living out of a van. But
I mean, it's not.
But you are currently in Arizona.
Sure. Yeah. Yes, that's correct. Yeah, currently in Arizona.
Currently in Arizona, and then decided for the winter he wanted to go to the Pacific Northwest, which is not where I would have gone for the winter. But
I'm telling you, we're working our way in there when nobody else wants to be there, so that when the weather is super nice and everybody wants to be there, I'm already there.
But I mean, you know why nobody wants to be there, right?
Yeah, I feel like coming from Pittsburgh, Pennsylvania, like throw anything at me, as long as it is above 11 degrees outside, I'm good. Like, it's warm. It's a heat wave.
Right, but it'll be cold and rainy every day. So it's like Pittsburgh, but rainy all the time. So,
all right, well, we'll record again in January, and I'll let you know how to move.
You'll be like, you were right. But yeah, we were chatting, and so we want to talk today about essentially buying and selling gyms. So that's coming up quite a bit. There is a lot of shall we say, exchanging of hands of affiliates in the space right now. So we kind of wanted to talk through, if you are going to buy or sell an affiliate, or you know somebody that is going to buy or sell an affiliate, please either listen to this or forward it to somebody who needs to hear it before they buy and sell, because Matt and I both have a couple of instances or examples that we're going to talk about today that are just not good, that are very recent. Like, I've got probably two in the last week that are, quite the dumpster fire as far as how things were executed. And because if you're buying, you do not want to be left holding the bag on something that is pretty catastrophic. So, how often do you deal with these, Matt?
I would say probably every third or fourth inquiry we get recently is somebody either buying, selling, or recently bought a gym. I mean, it is very prevalent right now. It's a very hot topic.
Yeah. Because who was I talking to recently about this? I think it was Nicole McCoy from HSN about it's just an unusually high turnover of gyms right now.
Yeah. And I guess I should preface that by saying, I guess a better metric would say about once a week, I'm getting an inquiry through our website for somebody buying or selling a gym.
Okay. I mean, that's a lot.
Yeah, it is. And what we're seeing is, it used to be you start an affiliate, you build it up, and then you go out and you find a second, you start a new one completely from scratch. And for whatever reason right now, there seems to be a lot of gyms out there that are either doing really well or just super burnt out. And so instead of opening up a new location completely from scratch, people are just looking to buy into a currently existing gym.
Yeah, well, you can get a steal in some of those scenarios. And there is an alternative option that I don't think people have thought of that we can talk about once we get there, in order to mitigate your risk there. But understand, anytime you buy another bit, you are buying, a substantial, in most cases, amount of liability, which is not necessarily always a bad thing. It's just factually that is what you are doing. So we wanted to kind of break this into pieces, but let's start with buying versus selling. There's considerations on both sides, right? Buying versus selling. Right. Obviously, we could speak pretty candidly about the CrossFit affiliate space, which is most people are not selling because the business is going really well. Right. And most people are not buying because they are sitting on a ton of capital and want to buy something that's hugely cash flow positive. So
right.
Those are typically a little bit easier. I can think of a couple. I know of one sale in the last 6 months. I know that was about $400K, which is a great sale.
Yeah, it is. Right.
But most of them are an exchange of assets. So talk to us a little bit about like what are the considerations depending on what party I am in this interaction?
Okay. So first we want to distinguish between what I will loosely deem as a stock sale, okay, versus an asset sale. All right. Now, I'll get into a little bit to say when we're talking stock sales, we're really talking about selling of a corporation, and oftentimes we have LLCs in this instance. And so really what we're doing is we're selling the actual business entity itself versus only selling the assets of that business entity.
Right.
So, and just real quick consideration there is when we're selling the business entity itself, the person selling is selling absolutely everything, all of the assets, the business, the liability, all the contracts, all the debt. We see this popping up a lot with like EIDL and PPP loans. And like you're loading all of that stuff. Okay. From a buyer's perspective, they have to be very careful with the stock sale because they're bringing on all of that potential liability. Now, on the opposite side of that, we have asset purchases and asset sales, in which I said they're literally just buying or selling the assets. So you're talking equipment, brand, lease, affiliate name, Facebook accounts, those sorts of things, but you're not getting all the liability with it. Right. So as we talk, we'll kind of distinguish between those two, but let's set that basis really fast.
So, and just to kind of like paint a clear picture here. So asset sale would be, hey, I'm buying all your stuff and I'm going to name it whatever I want to name it. Meaning like, I'm not actually going to assume your affiliate and all that kind of like you had CrossFit is the best. And I'm like, yep, I just want your equipment. We're going to move the location or you can dissolve that, whatever you want. But tomorrow it's going to be CrossFit is the second best. And we're going to set up shop in that same location. That would be an asset.
Well, sometimes they will include the CrossFit affiliation within the asset purchase. Yes. But what I'm talking about is if I,
right. But that's different though. Right. So that's important to distinguish because at least currently, and this is the point of this podcast, currently you cannot have your business entity cannot have the name CrossFit in it, meaning like they will not accept your affiliation. It has to be done under a DBA. And if you were old school, you probably you might have that. But right now it has to be, Matt's Health and Fitness Industries, and I'm going to DBA it as CrossFit is the best.
Right. Exactly. Yep, that's exactly right. And so what we're not in a stock sale, we're literally selling Matt's Health and Fitness LLC.
Right.
Whereas in an asset sale, I'm just selling all of my equipment and maybe the rights to that CrossFit name.
So, I mean, and there's no perfect answer here, but just based on that, I would be much less inclined to do a stock purchase and I would just do an asset purchase. And I was like, no, I don't want the name of your business. Like I've got my own, you can keep all of the dirty laundry that you have. And I'm just going to purchase your equipment and then I'm going to set up my own LLC in that same shop.
Right. And 9 times out of 10, we're just doing asset purchases. That's exactly right.
Yeah. I know of one that I know of in the past week that we got, I mean, like this is the part about not ignorance is bliss, right? Like you don't know any better, but like I was talking to a gym owner and the buyer had taken out all sorts of crazy loans against the business without notifying, or excuse me, the seller, the seller, not the buyer, the seller without the knowledge of the buyer. And then they completed that and then they were stuck with all this shit. And it was just like, dude. And so they end up having to shut the whole thing down.
Yeah. Right. Now, from the buyer's perspective, I will say if they happen to be listening, the contracts probably weren't done properly, so they could probably unwind the sale anyway. But
I mean, hopefully this one was overseas. So I don't know how, like, I don't know how that's going to work. Yeah, just like you're probably screwed. But yeah, and that's actually worth noting is that a lot of people, and I've been through this too, are like, oh no, you have to take it. And I'm like, actually, that's not how the law works. I'm going to take you to court, and the court system will settle this, because you can't just hose me on a deal, because I signed something unknowingly or out of ignorance, So if you did get screwed over, you should talk to a lawyer. They're going to be like, yeah, they can't do that to
you. Anyway, so from there, you said, so what are we considering once we kind of decide stock sale, per asset purchase, whatever it is? Now we need to look at, are we talking to the buyer or are we talking to the seller? Because generally speaking, once we go into one of these, usually, and I'll kind of talk about this and say very sort of tongue in cheek, these are not very sophisticated sales or buying. And I don't mean that as insult to anybody. We're not sophisticated business owners. We're not dealing with a bunch of partners, and we don't have assets. These aren't $1 million deals or anything like that. So usually the onus is on the buyer to go out and find the attorney to produce all of the documents that we'll inevitably talk about. However, in these instances, we don't always have that, because sometimes it might be the gym owner selling to one of their head coach, or it's a new time business buyer, and they don't have any money anyway. They have to go get it completely from funding, and so the seller, trying to be a nice person, agrees to absorb the cost of all of the essentially like our fees and all of the drafting fees and everything else. And it's fine. Sometimes there are advantages to that. But we just need to determine sort of who we're talking to and what the end goal is. And then we can sort of direct the conversation that way, once we know who it is we're talking to.
So let's do this. I think it's in the feel free to disagree with me. Actually, I feel like it'd be in the best interest for us to talk to the buyer specifically. Like, that's the person I'm most concerned about, right? Like the seller, because if it's fair to the buyer, then it would by default pretty much be fair to the seller for the most part, right? The seller's not going to agree to anything that they don't want to sell, but the person who typically loses in this scenario is the buyer.
That's right. Yep. Yeah, so I agree with that.
If we're talking to the buyer, what are some of the things that we need to consider?
Okay. So after we get over asset versus stock purchase, let's just talk asset purchase, because that's going to be the majority of the things that the situations that we're going to see, or it's the majority of the situations that we're going to recommend. Okay. So from there, we now kind of divide this up into 3 phases. Okay. One is making sure that we have the proper entity set up to actually go through this purchase. Okay. So you and I have talked in the past about setting up a proper corporate entity and operating agreements, all of those things. But in case they didn't listen to that episode, go back and listen to that episode. But in the event that they didn't, you can't go through all of this as an individual. It's a really, really bad idea. So if you're going to buy the assets of another gym, you yourself need to go ahead and form your LLC, or you and your partners need to form an LLC. And that's going to be sort of like, as soon as this is like you and I get together, we're like, hey, we're going to buy a gym. And as soon as we greenlight that idea, that should trigger us immediately to go file an LLC, because everything beyond that point needs to be done in the name of that entity. Right.
Okay.
And so we've got really 3 factors, or three steps at this point in order to form that entity. One is the state filing. Whether, again, let's just kind of proceed forward with an LLC. That's the easiest way to do it. So we file the LLC. As soon as we get confirmation of that, we go out and we open up a business bank account. And whether it's you yourself or you've got partners, we need some sort of an operating agreement to give the LLC power to go through the remainder of this transaction and give it money and get the legal protection and everything else. But that all comes through that governing document of the operating agreement.
Okay.
Okay.
And then, so we've got the LLC, we got that set up, and we can now, you know, in air quotes, safely go through with this acquisition, meaning like I'm not doing it under my own personal name and opening myself up to a tremendous amount of risk.
Sure.
Then what do we do?
Okay. So now we kind of start to enter into phase 2, which is the actual buying of the gym. So you have conversations now with whoever is that's selling, and you guys kind of come to an initial agreement about maybe how much you're going to pay for the assets. And then I'm going to talk with the gym buyer about what are called conditions upon the sale. And these are going to be things that essentially have to happen from point A to get all the way over to like point C when we're actually going to, you know, like give the seller the money. Okay. The first thing we're going to do is we're going to tell the seller that they need to reach out to their landlord and figure out what's going on with the commercial lease. And because a landlord can stop this from all happening very quickly.
Right. And I've had my fair share of run-ins with landlords, and like, this is one that everybody forgets. I'm like, the landlord is like an unwanted third party in this whole thing.
Yes, it is. That controls a lot. Because in your commercial lease, I'll almost guarantee you that you have a limit on subletting, assigning, or transferring the lease. Okay. And basically what that means is if you're going to sell your gym and you are in the middle of a lease, obviously as a seller, you want to get out from under that lease. And because that's a contractual relationship with the landlord, it is literally up to the landlord whether or not the landlord is going to let the seller out of the lease. So that's sort of really right there. As soon as we've greenlighted it, we've got the corporate entity set up, you're having conversations with the seller, somebody needs to get a hold of that landlord to get the landlord on track with either assigning or transferring the lease. So once we've got that, you know, now it's just a matter of that. Anyway, sorry, that's going to be a giant, what's called a condition upon the sale. In other words, as the buyer, you're buying all of these assets. Typically, you're going to just plan to continue to run the gym in its own location, right? So a condition is your ability to sign into that lease. And so we're going to advise the buyer that if they're not able to sign into that lease, the whole deal goes away because they're not going to want it at that point.
Right. Can I add something to that? Because you've mentioned two things, and I think it's important for people to distinguish. And I know because I have been sued over this. Because you talked about assignment and transfer. And so an assignment, so like, let's say that I'm buying from you and so you hold the current lease. An assignment means that you as the seller, when I buy it, are still liable under the terms of the lease. Where a transfer means that like now you as the seller are completely removed. But when you're going through this process, it's important to understand that, you know, for both people, because if you're the seller, you don't want to be involved with that transaction anymore. And if you're the buyer, now you can be liable to two parties. You can be liable to the person who you are assigned under as well as the landlord, and you get double screwed.
Right. Yes. It is not, we never want an assignment, but some landlords will force the assignment because the landlord now gets that double liability and gets to maintain the liability with the gym owner that is already established and has been paying rent and everything else versus essentially agreeing to enter into a lease with a whole new business.
Yep. So, all right. So let's assume we get best case scenario and we're like, all right, we get a transfer of lease. I'm like, okay, so we can continue to move forward instead of saying, all right, well, you got to shut this thing down.
Yeah, right. So while we're having this discussion with the landlord, and we have sort of the preliminary negotiations with the seller. Now we're going to start to put all of that down in writing. And this is called a letter of intent. And so the letter of intent is essentially me coming and saying, I'm a buyer, you're the seller. I'm going to offer you X amount of dollars, sort of paid out under these terms, and we're going to put all these conditions on it. Here you go, sign. We're agreeing to enter into these negotiations. And the biggest mistake that I see once we hit letters of intent is when gym owners decide to just do this on their own, and it ends up being what's called a non-binding letter of intent. Okay, we're sort of agreed to these preliminary terms, but if we leave it in a non-binding letter of intent, you as seller, and technically me as the buyer, now have an opportunity to just walk away whenever we want. Okay, if something's not right, or you find somebody as the seller, you find somebody who's going to offer you like 10K more than I'm offering you, you can technically shoo me away and go enter into this agreement with somebody else. So we need to reformat letters of intent to have binding provisions that, especially when you're the buyer, that provide you exclusivity to buy the gym for a prolonged period of time, so that you don't worry about the buyer or the seller just going off with somebody else.
But correct me if I'm wrong. That doesn't mean I am obligated to the purchase, right? I still have the opportunity to opt out at some point.
Yes. Okay. And so we will, and again, a lot of that does go along with like a condition. One big condition is satisfaction of what's called your due diligence, which is basically checking the books to make sure that the gym is actually worth what the seller's trying to sell it for.
Right. Okay. Yeah, I just wanted to clear that up because somebody would be like, binding, that means I have to buy it now. I'm like, nope, you can still walk away.
No. You can walk away. It's just from the buyer's perspective. And I had this conversation with a gym owner. Again, a perfect one of these situations. This gym owner is going out and the goal now is to buy up about 3 local locations and start up sort of so kind of like a franchise within these 3 or 4 different locations all in the same area. And he tried to do the letter of intent on his own, was then nervous about the fact that he couldn't lock these gyms in until the actual closing of the asset purchase. And the way we fixed that was by going back and redoing the letter of intent that provides an exclusivity clause that says this buyer essentially gets 60 days to close. And if they don't close within 60 days, then the sellers can back out. But we just rewrote the letter to be a little bit more exclusive, a little bit more binding. You don't have to, and don't be afraid of that. You don't have to, but he wanted it to be. So we reworded that letter of intent a little bit to really kind of make sure that we were locking the sellers in there.
Got it. Okay. All right. So from there, so we're starting to get all of this, and then what are we doing?
Yeah. Once we get the letter of intent, now we're really just negotiating the final terms of the sale itself. So now we're talking, can the buyer actually get funding? Does the buyer get through the due diligence and agree that the gym is actually valued at what it was valued for? Can the buyer get a transfer over of the commercial lease? Sometimes if buyers are a little bit nervous about it, we may even put conditions in there that say something like the seller must be able to show a maintaining of 75 to 80% of active paying clients from the time of signing the letter of intent to the time of closing the asset purchase. There may be other things like they want the seller to stay on as a coach for 3 months afterwards in order to help with the transition. We're negotiating all of these terms so that we're ultimately getting ready to put something together, which is called the asset purchase agreement.
Well, what you just outlined there is what I don't see. I think the buyers, in a lot of instances, want the seller to go away. I'm like, right, but it would be in your best interest in some situations to keep the seller hooked to that, so that if they blow it up on the way out the door, that you are not just left there with your pants down.
Yeah. Yeah. We've had some savvy buyers come up with some really interesting terms on that too. Again, they may require that they show certain percentage of ownership. We've had buyers want to break it down so that only a certain portion of the purchase is provided at the actual time of the closing of the asset purchase agreement. And then 3 months later, if they're still able to maintain a certain amount of membership, then they'll give a little bit more money. And then 3 months later, if they're still able to show the same amount of membership, they'll give the remainder of the money. So there's a lot of power you have from the buyer, as long as you can get the seller to agree to it. But there's things that a lot of buyers don't consider that they should be considering, like these clauses that help
you should
make sure that they're walking in.
You should be covering your ass. Now here's what I'll tell you is very likely is that there's probably some dummy who won't do this, who will give the buyer or the seller what they want, and then you might lose out on that deal. I could very much see that happening. But if you are buying, you should absolutely mitigate your risk as much as possible, which is this is what they do when large corporations buy, they buy out a company. They're like, hey, we're going to give you, a nice payout as the founder and CEO, but you're going to stick around here for 3 years and run this bad boy. And your paycheck and payout is contingent upon you not just planting a bomb in this thing.
Yeah.
And I think most people don't think about that. And this is why we see all these horror stories of, I sold the gym to Matt, and then Matt stuck around, and then he caused hate and discontent, and then everybody left when Matt left, and they're just like, well, yeah, but Matt shouldn't. That was my fault as the buyer, putting Matt in a position where he could do that to me instead of essentially legally handcuffing him and be like, yo, you need to behave. You can't just come in here and break shit, because I will rake you over the coals legally in this scenario. And I think people don't think about that because we just want to get him out of here. And I'm like, no, you want a healthy business long-term, and don't get it twisted. That gym owner will screw you over in some instances. And whether you think so or not, but you know this, you're a lawyer. When doing legal transactions, you should always CYA yourself, always, no matter what. Always assume the worst, cover your ass, and just assume. You just have to assume the worst. You can be like, oh no, we're good. And then I've seen some crazy stuff from gym owners and purchasers. I'm like, we were best friends, and then he stole everything, and you're like, oh, okay, right? Crazy shit, dude. You're just like, what is what is wrong with this person? And it's just you don't know. You and I talked about this on the when we were talking about the operating agreements, which is these well drafted and crafted legal documents force people to behave.
Yeah. Sorry, I got an error there. Are you still around? Okay, yeah. Sorry, I got an error on my screen.
No, you're good.
So another thing that we can do to help CYA is non-disclosure agreements. Right. Or NDAs, as they would most commonly be. And that's, it's something that we always advise gym buyers to ask for, just to help prevent these sorts of situations. And a lot of times you'll get pushback. This is sort of one of the areas where, if you say where do gym owners sort of mess up oftentimes on these, and it's not going to the lengths of covering themselves, because they'll be like, no, I've worked for the gym owner for a long time, and we're best friends, and they're not going to tell anybody, or everybody already knows what's going on, so we don't need an NDA. It's well, I get it, but things can happen between now and the end, and it doesn't necessarily mean everybody's going to be friends about it. So let's just everybody keep their mouth shut.
Yeah, because and I think the other thing is because you don't know what harm can be done, intentional or unintentional, by that information getting out. So it's just set it up that way, which is again, you're safeguarding your asset that you're buying by doing it this way. Yeah. And then when everything's done and just all right, everybody's super happy. I'm like, great. But you would have been unhappy had it not gone that way.
Right. So we're working our way through, and now we get to the actual asset purchase, the quote unquote closing. at this point, and that's a big, long document full of a whole bunch of legal language that basically says you have the right to sell me the assets. I agree to buy the assets. We'll pay. We'll cover each other's or our own taxes, and that's the actual that's the bread and butter of the purchase is the asset is signed. That's pretty much everything is done, and there's now a legally binding document that says you as the seller can now not back out, and you have to give me all of these assets, and I can move in and start operating the gym.
Got it. What one of the questions, or what's because I know there's different points where money can be exchanged. Like, where have you seen people go wrong with like the actual like, yo, here's your money? Because I was listening to another one the other day, which is like I paid him 50%, and now he's dragging this out, and I was just like, why would you do that? Like, I'm gonna wait until the very last second again to make sure that like you are gonna do what you're told or what you're supposed to before I give you any money, because we've all seen that with either contractors and like all sorts of, like, I paid him 50% up front and it took 12 and 18 years to get the damn project done. You're like, well,
yep.
You know.
So one of there's a lot of times when we're giving money up front like that, it's considered a good faith payment, right? So a seller might say, you know, this is a good faith payment. You're going to pay me 25% of the ultimate purchase price. And hopefully the buyer's getting something for that. Okay.
Right.
But the first thing I'm going to suggest is if you're going to do that, then don't actually give the seller that 25%. We put it in what's called an escrow account.
Escrow.
Yes. Put it in a separate bank account that nobody can touch, that it's just there. And so the seller knows the money's there, but the seller can't actually touch it until we get all the way to the closing.
You know how to speed up a purchase real quick? Put that seller's money in a bank account they can't touch.
Put it in escrow. That's exactly right. The thing is, now if we're going to do that, we need additional agreements, of course, but we need to be a little bit more specific with that letter of intent, because we need now provisions that say by the time we get to the signing of the asset purchase, if any of this falls apart, we need the seller to agree in writing that that 25%, whatever it is, comes back to the buyer. So that's always a danger anytime a seller wants some sort of a guaranteed payment or some sort of money put off to the side. That's fine. Just buyer that needs to be like a key for the buyer now to reach out to somebody to say, okay, wait, what do I need to do to protect myself here?
Right. Okay.
Another issue that I've seen is people who just got this one morning was the landlord who wants to see the signed asset purchase agreement before they'll agree to assign or transfer the lease. And I get why the landlord wants to see that, because the landlord wants to be able to see that the purchase is actually going through. However, that's if you're the buyer and you've just signed an asset purchase agreement binding yourself to purchase all of these assets, let's say for $100,000, and then you get to look at the lease, what are you going to do if you don't like the terms of the lease?
Right. You're like,
you've already signed an agreement. Yeah. So, you just, there's a certain steps to how this process goes. And there's numerous ways that you can mess up. I had another gym owner ask to wait.
Hold on, before you go to that one.
Yeah. Okay, go.
We'll go back to the landlord one, because like, what if the landlord says that, like, what would I do? Would I just, would I abandon that purchase?
First thing we're going to do is we're going to push back at the landlord and say, we'll show you the draft of the asset purchase agreement, but we're not going to show you a signed asset purchase agreement.
Yeah.
And so that should satisfy the landlord to at least show that this is actually happening and it's going to go through. There's, we can show the landlord proof of funding, things like that.
Right.
If the landlord still pushes back and is requiring the showing of a signed purchase agreement, then we're just going to have to be super clear in the asset purchase agreement that says the ability for the lease is a contingency, and if that doesn't happen post closing, that the seller agrees to allow the buyer to back out. Yeah, we're just and then we will probably post date. We'll probably post date the payment of the purchase money as well.
Which again,
so that way we don't end up in a situation.
I'm assuming,
go.
Right, but that's where escrow would come in and correct, meaning like, hey, that's held there until all paperwork is done, including the landlord's paperwork and everything.
Yeah, exactly right. That's exactly right. So we just need to be very aware of that, so that from our buyer's perspective, we can start to put little protections in place, again, covering the buyer, so that the buyer doesn't end up in a really bad situation.
Yeah. Okay. So what other things should people be concerned of, or what's you were going to bring up another scenario that you just saw?
Yeah, now actually it just completely skipped my mind.
I know. I knew when I asked you that it was going to happen, but I really didn't want to. I didn't want to skip over that because that's an important piece. You're like, okay, what happens if
no,
we
it
do
is.
that? Yeah.
Right. No, it is. And it might come back to me what that other scenario was. It's gone. It's completely gone now.
It's okay. What other things should, as the buyer, should we be concerned with? And then we can talk about the seller a little bit as well. But as the buyer, what are the things should we?
You
remember?
Yeah, it just got to me, because I was mentioning the steps in which these things have to take place. And, step one, I mentioned earlier, has to be that setting up of the core entity that you're going to use in order to go through all this stuff. And I'll have discussions sometimes with gym owners, which, I mean, understandably from the buyer's perspective, they don't want to invest a lot of money only to have that purchase fall through in the long run. But remember, you're signing legal documents throughout this entire process. Once we start with the letter of intent, that's a legal document. And then maybe we have non-disclosure agreements, and then we have asset purchase agreements, we have non-compete agreements, we have to review and sign a lease. All of this has to be done in the name of your legal entity. So I've had gym owners say, well, can't I just sign all of these documents, and then only once I know that the asset purchase agreement is going to go through, then actually file the LLC and pay for the drafting of the operating agreement, et cetera? And the answer is no, you can't do that, because that's going to leave us open to one of two scenarios. Either one, you've gone through and signed all of these legal documents up to this point in your own individual name, which means it's not binding on your LLC at all. Or I've even had a gym owner say, well, can't I just put the name of my LLC in there, knowing that I'm going to file it in a couple of months? And that's big no.
No, that's like signing it for, I was going to say, it's like signing under a fake name. Bob doesn't care, just like, that's not real. Yeah. Right.
Oh. That's exactly right.
Okay.
The other big issue that we see from the perspective of the buyer, besides the buyer thinking that the seller's a really good guy, and you and I both know that that's not always true, is again, the buyer attempting to streamline this process or save some money by doing pieces of it themselves. Okay. I think I mentioned a few minutes ago, the gym owner or the gym buyer who wanted to do their own letter of intent and then realized that it was insufficient for their ultimate goal. I've also seen gym, let's see. I saw a letter of intent once where, the buyer wrote it and named an unfiled entity, which the seller said, "Oh yeah, my gym is such and such LLC." Okay, I'll go check that out. Checked it out, doesn't exist. Went back to the seller and said, "Wait a second, that LLC doesn't exist." And they say, "Oh wait, maybe it was a corporation." And so then we have to go back and we check, and sure enough, it is a corporation. But then they don't have, some sort of updated file document with the state, so that it's currently suspended. So
then now you have an entity that's in not default, but that is DINK with the state, so that you can't even actually make a sale or a transfer because it's
right.
Technically that entity is in violation of state business laws.
Yeah. That's right. Meanwhile, the buyer now has a letter of intent that's addressed to, one, an entity that doesn't exist, or two, an entity that is suspended. And all of this could have been prevented, need I say, by getting, proper help and not worrying about saving a little bit of money in an effort to go through the process. So that can cause quite a bit of frustration, as I'm sure, you could speak to a lot of gym owners who you guys tell them what to do as far as running their business. They try to streamline some process and you're left kind of beating your head off the desk. Like, this could have been prevented had we just done this the proper way from the very beginning.
We've like changed how we onboard people and well, it's some, which is like one of the things I say is like, do not under any circumstances make any major decisions without telling us. Right? Like nothing. Don't buy another business. Right. Like you're like raising rates. Don't buy another business. Don't sign a new lease. Like don't do any of that shit because like A, we have resources that we can help you with that. But B, you don't know what you don't know. And like, I'm going to ask you a series of questions that you probably don't have answers to, at which point, like, that should be your prompt to be like, go do more homework before you get yourself in hot water. And every single time somebody does it, I'm like, I fucking told you. Like, that is literally why we're here. We are not here to just, did you do your homework? That's not what we're here for. I'm like, we are like fully like vetted, fully integrated advisors for all of this stuff, dude. Like, it's not just me and Jay in our basement. Like there's a whole team back here of like people that have all this shit like ready to help you out. Like, just ask.
Yeah.
So God, people are just crazy. I'm just like, why would you think that's a good idea? I'm like,
because they don't know. But again, that's why we're here, because we do know, and we're here to answer. I know.
Right.
All right. So we've got to the asset purchase. It's closed. Are we done? No. Okay. Once we actually get the asset purchase agreement signed, not done yet. We've now sort of finished phase 2 of this, and we enter into phase 3. So from a buyer's perspective, really, as the seller, you're now done. You can go away. Phase 2 is done. Phase 3, though, goes into the buyer. So now we have assets and we're cool and we're ready for the gym, but we now have to go through the process of, okay, well, what's the membership contract? What's the liability waiver? What's your staff agreements? What's your sublease agreements?
Right.
We have to then vet sort of the same audit that we would perform on a currently existing gym in order to determine the validity of their legal contracts for their members. We now have to do that with the buyer, because sort of like the last worst mistake that the buyer can do is absorb all of this, spend $100,000 getting all these assets and everything else, and making the assumption that because this gym has been functioning for 5 years with these legal contracts, like the waivers and the membership contracts, making the assumption that and the new gym owner is just going to use those same contracts. And that can be a really bad idea, because you spent $100,000 to buy this gym, and now you've just left yourself wide open and exposed with terrible legal contracts.
Is there any way, so obviously if you didn't do that, so the short and sweet of this is when you come in and like waivers, contracts, everything, you must 100% of your clients will need to sign new ones. That is because they don't have an agreement with you. They have an agreement with Bob, who just left.
That's exactly right too.
So now it is all void. Is there anything that we could do to shore those up in the interim? Meaning, like, is there any way where I can start that process, or is there way to mitigate that, like when I take it over, so that all of this is done and people just can't walk out on contracts?
Yeah. locking people in before the asset purchase actually goes through can be a little bit tricky, you know, like having
Right.
your members, your new members now sign like a membership contract before you've actually essentially
Right.
bought that member. That can be a little bit tricky, but you know, we break this up into like phase 1, phase 2, phase 3. We can blend all of this stuff together. It just depends on how forward the gym owner, the new buyer, wants to be. So while we are negotiating the letter of intent and trying to get it to the asset purchase, sure, I can go ahead and start drafting liability waivers and membership contracts and staff agreements and things like that. So that way, once that asset purchase closes, and you know, let's say you take over Wodify, you take over the push press, whatever it is, you upload those templates that we've already produced for you and just blast them out to all of them. Yeah, you can in that a little bit. Sure.
Okay. Yeah, I was just curious because like, not that it happens a lot, but every once in a while you do have a purchase and then like they're done, everybody's here, and they're like, and then like they start to try to update things, and then there's just massive fallout of people because they're like, oh, I don't want to sign this contract, I'm out of here, and you're just like, oh shit, like that's like now what I just purchased is worth 50%.
Yeah,
you know,
exactly
from what it was 2 days ago. You know.
Yep. Yeah, I had a recent buyer try to protect against that by offering the owner, what was it? I think it was something like $150 per member who was still a member of the gym 3 months after he bought it. And so that way there was an incentive on the seller to make sure that the buyers continued to, or the gym members continued to maintain their membership after purchase. So there's little savvy things we can do in there to try to protect the interest of the buyer.
Yeah, I mean, I didn't go to math school, but that's $15,000, which I would take it if I was the owner, going to get a little extra cash on the back end of that.
Yeah, that's exactly.
Well, that's
right.
actually. Could you? Well, you can write anything into a contract. You could write something along those lines in here, which is like, hey, you're going to get this here, and this here, and you'll get that final payment, you know, at the 90-day mark, based on, you know, you can't say everybody because you can't guarantee that, but like, let's just call it 80% of the membership day starting here. As long as they're all still here, you'll get that last 75%. That way they don't tank the business.
That's exactly right. Yeah. And you know, with some exceptions, you can put anything in these contracts that the seller will agree to, and vice versa. From the seller's perspective, you can put anything in contract and get the buyer to agree to. And I say that loosely because there are exceptions, but for the most part, that's right. Where we come in with something like that, and where you guys would come in with something like that, is getting these ideas, because we've been there, we've been experienced, we've done this. We can go and say to the buyer, these are the things you need to consider that the buyer doesn't otherwise know is available to them.
Yeah, they're just like, oh, I just have to. It's like, I'm just going to buy a car, and then we just walk out of there and we're done. I'm like, actually, no. That is not at all what you're doing.
Just don't give somebody $100,000 for a key. Yeah. Please don't.
No, no. You know, the other thing that I have seen but don't really understand is looking at so acquisition. So a lot of the purchases are relatively close, right? Meaning like geographically they're relatively close. And I'm like, well, and there's, I think, looking at it differently. So rather than an acquisition, I think people should look at it a little bit more like a merger, which is like, hey, I am going to purchase all of this, but I'm actually, you know, as long as it works with the landlord and some of these other things, that you could work that whole deal out, which is like, I actually don't want all of the liability. I just want the members, so I can shut this entity down and then move them all over to my facility, at which point you have mitigated almost all risk, and you've baked into the cake that like you could have a significant drop off of that clientele and still make the deal financially viable, you know? And I think a lot of people don't think about that. I'm like, you'd probably be better off running one facility anyway. And I'm like, just you could buy it and then essentially shut it down and then move everybody over. And I'm not saying you just go in there and shut it down. Like that would be a very thoughtful process in how you migrate everybody over. Yeah. There would be an agreement with the gym owner there to make sure that they helped facilitate that transition. Like I would make sure all of those things are in there. But that would be the safest bet for you as a gym owner, because what you'd be doing in that scenario was essentially only buying the revenue and none of the liability.
That's right. Right. So, yeah, you're not worrying about the lease or anything. And a quick note, if you just spark the idea in a seller and they're like, oh yeah, I'm just going to sell my membership. Just a quick idea there are states that require you to receive written permission from each member prior to a transfer like that. So you can't just sell your client's information to a buyer. So, what you'll want to do, and let's say again, a seller is listening to this, like, oh yeah, cool, let's do that. First, redo your membership contract to require the right to assign your client's details to a buyer. And there's legal language that we put standard in our membership contracts that allow the gym owners to do this. So now you have it in writing from the gym member that you're able to assign your information to a buyer and then go through the process. Maybe that's the next episode is we talk about all this from buyer's perspective, or I'm sorry, the seller's perspective. But
seller's perspective, yeah.
That's just something that the sellers need to consider. Yeah.
Well, I mean, I like to typically, at least for what we're doing, I'm more looking out for the buyer predominantly, because like those are the people that are going to be running CrossFit affiliates. So who's I'm worried about. Like I hope I do. Yeah, I want the seller to get a payday, right? I want that person. If you're in a good business, you should be rewarded and you should be able to have that exit go really smoothly. But we're talking primarily about buyers here, because like I'm worried about somebody who's going to assume and take over a CrossFit affiliate, and I want them to have the ability to do so. And if you mess up some of these things, you really, really put yourself behind the 8 ball as with regard to being able to operate and get this thing running the way that you want it to. So this is kind of why we're talking about from the buyer standpoint. But I do think it'd be useful. Right. Yeah, but I do think it'd be useful to talk about from the seller standpoint too, because there's a lot to be discussed there as well, with regard to how do you even go about starting that product? Who are you going to sell it to? Like there's so many things to be like how far in advance should I start to figure all of this out? Newsflash, it's not 3 months, So,
one real quick note, one more real quick note on the buyer stuff. We talked about landlord having the ability to shut this down, or the amount of time it can to get a landlord on board to do something like this. No shade at CrossFit. Once you get that letter of intent signed and you are buying somebody else's affiliate, get CrossFit on board too, because they're not exactly fast at the affiliate reassignment process. Just something else to consider is if you're buying
they're getting better
affiliate name, get a hold of them.
They are getting better. I know I've known of a couple of them in the past couple of months, and they've happened relatively quickly. So they've gotten significantly better at that. I want to give props where due. But yes, you are correct. In the past, that has been not an expedited endeavor,
quick process.
So so if you guys are listening to this and you're thinking about buying an affiliate, if you know somebody that's thinking about buying an affiliate, please share this with them, because I guarantee you, if they thought of a couple of these things, they definitely didn't think of all of them. And the whole purpose here is just like, we want people to run good affiliates, and you cannot run a good affiliate if you start it on the wrong foot, because everything is harder here. Like now you have all this undue stress. You might now take on additional financial burden. And when you're trying to get an affiliate off the ground, is the last thing that you want to be dealing with. You want to walk in there and be like, yes, we did it. We're good. Let's make these people as happy as possible.
Give them the best hour of their day.
Best hour. Look at you, Matt. Look at you. You should start a marketing company. If you guys have more questions, you guys go check out Matt at Gym Lawyers. It's just gymlawyers.com, correct?
Yeah, that's right. Yep.
Yep, gyምላwyers.com. We refer a ton of people to Matt for different stuff because people ask me all the time to look over their leases, and I'm like, I can read, but I am not going to give you good legal advice. So you should not ask me what I think about your lease. But yeah, he's a tremendous wealth of knowledge and an affiliate owner as well. So go check him out. If you guys got questions, do not ask me for legal advice. I am not a lawyer. I will not answer that. Matt is a lawyer and can direct you towards what he can help you with. So, dude, as always, I think this is super informative, and I think that's what people love about this stuff. So I appreciate you coming on.
Yeah, my pleasure, friend. Anytime.
Cool. All right, guys, we will see you guys next time. If you have not tried your free trial period for the knowledge, and I don't know why you don't want to be a good coach, so go try that out too, and we'll see you guys on the next episode. Thanks for checking out this episode of the Best Hour of Their Day podcast. We appreciate you listening and choosing to have us help you in your passion for coaching and affiliate ownership. You can find more episodes just like this on all podcast platforms. If you're interested in learning more, you can reach out to us on any social media platforms, or you can visit www.besthouroftheirday.com to book a call. If you found this episode helpful for you, please share it so that we can help other coaches and affiliate owners to help build a bigger and stronger CrossFit community. Thanks for listening.